Sorry to വിളിച്ചതിന്.
Yeah, did you get the link? It will be there on that.
Yeah, copy the streaming link അല്ലേ? View stream on YouTube. Okay, done.
ഇപ്പൊ വരും.
So it's done.
Yeah, so now I'm making you the host, okay?
Now, yeah, I'll do that.
Yeah, okay. I'll join in a while, okay?
Yeah, fine.
ശംഖു ശംഖു
Welcome, Dr. Beta.
Good evening, sir. Good evening. How are you?
Fine.
Good evening, LB sir.
Good evening. Good evening.
Welcome to Idea Tripura.
Thank you. Thank you. We are expecting more people, or are we going?
We wait for 5-10 minutes.
Yeah, sure.
Because the link നമ്മുടെ തൃപ്പൂണിത്തുറയുടെ പുറത്തോട്ട് ഡിപ്പായി പോയിട്ടേ ഉള്ളൂ.
Okay. No problem.
സാധനം എടുക്ക് കോല് കോലെടുക്കാൻ ഹെഡ്ഫോണില്ലാതെ പറ്റുന്നുണ്ടോ? നോക്കും
All the delegates are requested to mute. Please mute. Bindu Anil Kumar, mute.
പോയി
James എത്തിയിട്ടില്ല.
ഡോക്ടർ ജെയിംസ് എത്തിയിട്ടുണ്ടല്ലോ. ഡോക്ടർ ജെയിംസ് തോമസ് ഉണ്ട്.
ചെയ്യാൻ പറ്റില്ല.
All the participants are requested to mute. Just check whether you are muted.
A very warm good evening to one and all, and appreciate everybody's time and effort for coming here to listen to the session after a tiring day of practice. So in today's world where everybody are more aware of their rights and responsibilities, it is a dentist's duty to be more aware of the medico-legal aspects in dentistry, so as to have a hassle-free dental practice. So welcoming you all for today's session, medico-legal aspects in dentistry. So before we formally move on to the session, may we have a silent prayer? May I now request President IDH Tripunthra, Dr. James, to call to order the meeting. Dr. James. Dr. James. I think Dr. James is not there. May I now ask the secretary to do the honors?
Yeah, sure. Good evening. The president is quite busy with some upcoming dentistry program. That's why he's not here. Anyway, I'm hereby officially call to order the meeting.
Thank you, Dr. Anup. So, all of you are requested to listen to the session attentively, as we have a quiz program that is being conducted by WDC IDA Tripunthura in lieu of Women's Day, Darshana 2022. And so kindly be attentive, everyone. So let's see who wins the exciting gift. So, and the audience are also hereby requested to mute themselves when the session is under progress. So let me now introduce a speaker who is a very accomplished personality in this regard. Dr. L.B. Peter, he is a professor, Department of Prosthodontics, Department of Orthodontics, Government Dental College, Kottayam. He had completed his undergraduation from College of Dental Surgery, Manipal, his PG from College of Dental Surgery, Manipal again. He holds a PG diploma in clinical research from the Annamalai University. He is also an LLB graduate from Mahatma Gandhi University. He has completed his PhD from University of Kerala in the year 2019. He also holds M.Orth RCPS from Glasgow and M.Orth RCPS from England. He is also a diplomat Indian Board of Orthodontics holder. So he has 22 years of teaching and clinical experience, and he has more than 30 publications, 15 national presentations, and 3 international presentations to his credit. He is also a member of Indian Orthodontic Society. He is the chairman, Board of Studies, Kerala University of Health Sciences, past member, BOS MG University. He is also the member of World Federation of Orthodontics. Then he has 30 scientific publications to his credit. He has co-authored 3 chapters in textbooks. His clinical interest is in mini implants, biomechanics, legal issues in the clinical practice, psychosocial issues related to malocclusion, etc. So may I now invite Dr. L.B. Peter for today's session. Welcome, sir.
Thank you very much for your kind words of introduction. Shall I share my screen?
Sure, sir.
Please enable for screen
No.
share.
Sir, I think you can do it, sir, now.
Okay.
Dr. Rahul, please mute.
Is my screen visible, Krishnamar sir?
Yes, sir. It's visible, sir.
Okay, all right. So shall I proceed?
Sure, sir. Sure.
Okay. Let me take this opportunity to thank the IDA Tripunthura branch for giving me this opportunity. The President James sir, Joint Secretary, Honorary Secretary Anup Kumar sir, and CD Convener Dr. Krishna Kumar for inviting me to this presentation. As mentioned, I work at Government Dental College, Kottayam. A big thanks to all the members, the delegates who are attending this program. I'm sure that after a hectic day of practice, you might be tired, but this COVID situation has made us to be at our own place and listen. So I hope you can relax and listen to it. Let me begin my presentation. So can somebody mute that? Yeah. Thank you. So the title which might have circulated among your flyer might have had this case-based analysis, but I must say that I recently had a presentation in one of the firm which had some case-based scenarios, which I am not going to elaborate details, but that YouTube video of that firm is available, I suppose. In that, I had discussed certain case situations, like for example, a 12-year-old female pediatric patient was treated for restorative procedure. The parents were made to wait in the waiting room, and the next day after treatment, the parents claimed misbehavior to the child, and the dentist and a big scene was created and threatened. So that was one scenario. The other one was like a 52-year-old otherwise healthy patient who underwent FPD treatment, developed cardiac arrest on the chair. Doctor tried to revive, but the patient somehow, it was due to, they could not save, and he passed away, and they lodged a complaint in the police station. A third scenario which I discussed was a 22-year-old male patient underwent orthodontic treatment. Later, few years later, they claimed relapse and threatens to go to court. And the fourth scenario which I discussed in that presentation was a 35-year-old female patient developed pain following RCT, and later when the patient went to some other clinic, they asked for extraction, and the patient's husband came for a refund of money from the clinic where the RCT was done. And a fifth scenario was during endodontic procedure, a file slips into the throat and the patient aspirates, and later he had to undergo some surgery to or endoscopic procedure to recover that, and the patient claims negligence. Now, a detailed description is available in the internet. I think it was for that online dentistry platform. It is still available, I guess. And today what I am focusing is basically a legal issues in clinical practice. And these scenarios are also being presented in between, like, which we can discuss in depth later, but as a brief session. So that is what I have done today's presentation. So I'm sure that you are a bunch of practitioners, and I am addressing to a bunch of practitioners after having a tiresome day. So I should not go to theoretical aspects, I'm sure, but a brief little bit regarding the evolution of our profession. See, our profession in fact began, or any medical profession began with the divine process of healing. We know that, I don't have to elaborate. Later, especially our profession has turned into an art of healing, because the art part of our profession is well known. And later it became a profession of healing, especially when the Dentist Act was introduced, and following code of conduct, everything, it has really become a profession of healing. Now, remember, when any vocation or any job is called as a profession, it has to fulfill 4 requirements. You are aware of it, I am sure. There should be an act to govern, there should be a structured course, there should be a regulatory body, for us the Dental Council of India, and there should be code of conduct. So our profession fulfills all these 4 requirements. So it is called as a true profession. And as time passed, our profession has now become like the trade of healing, especially when Consumer Protection Act came into being, Clinical Establishment Act, Indian Contract Act, Drugs and Cosmetic Act, etc. So we are right now in the midst of being a profession of healing as well as kind of trade of healing. We cannot underestimate this. So keeping that in mind, I should ask this question: why there should be laws to regulate a profession? Ideally, any profession should be self-regulated. And we know that degradation had creeped in, as with any other profession. For example, we might have heard that, corporate hospitals putting a brought dead patient in ventilator, or organ transplantation racket that have been happening, or doctors, forced to do defensive medicines. So there was a need for the profession to be regulated. And finally, because of these regulations, what the authorities have done is they have monopolized that practice of dentistry or medicine to us. So Dentist Act prevent others from practicing dentistry to us. So that is the benefit that they are giving because of the professional laws. Now I can elaborate this with an example, because especially when youngsters, dental students, they will ask, like, why are these many laws and binding to us? Just imagine that if plumbing becomes a profession from tomorrow onwards, there will be 4 requirements, as I mentioned before, like an act governing, a council in which the register of all plumbers' name will be ensured, maintained. There will be a structured or a certificate course, and there will be a code of conduct. So in return to this, what the government ensures that whoever does plumbing other than whose name entered in the book will be considered illegal. So that is exactly that is done to our profession also. So obeying laws related to profession is one way. If you're looking at it, is the penalty that one has to pay for job monopoly. That means they have monopolized the job for us. But that doesn't mean that everything is well and good here. Okay, in this journal report, it says that 2,500 to 3,000 quacks practicing dentistry in and around Delhi. Maybe in Kerala, we may not face this as a big issue. Now, let me classify the laws that one has to obey to practice dentistry. You all know this. As a citizen, as an ordinary citizen, we are bound to obey the Income Tax Act, the Information Technology Act, GST, civil and procedural laws. As a person doing trade or practice in a commercial establishment, we are supposed to obey the Panchayat or the Municipalities Act, the Rent Control Act, Transfer of Property Act, land laws, electricity laws, Environment Protection Act, based on which our image and waste collection, everything is being done, Consumer Protection Act, etc. And the third set of law is obviously the professional laws, which I already mentioned, like Dentist Act, Drugs and Cosmetic Act, Clinical Establishment Act, etc. So overall, there are 40 laws to be obeyed for a person to practice dentistry. So this will put these kind of questions to your mind, which I am trying to answer in this presentation. Like, are doctors handcuffed with laws? Is it good to control medical profession with laws? What are the laws to be obeyed to practice dentistry? Is medical profession included under Consumer Protection Act? Are patient consumers and are we mere treatment providers? And how to safeguard our practice? Or is indemnity insurance a solution to negligence claim arise by patients? So these are some things which I am trying to look into in this presentation. So let me start with a brief introduction of the doctor-patient relationship, which I'm not going to bore you with the details of it. We know that doctors were considered as God. Patients and the older time considered our doctors as their own family members. Medical profession was noble, power of healing, divine, etc. But remember, this is the change that happened. Consumerism has creeped into the both doctors and patients. Now, remember this carefully. It's not us. They have defined themselves as consumers under Consumer Protection Act, okay? And they have defined we or us, doctors, as mere service providers. It is not we who have defined, okay? And our treatment, they have defined as service, and they have given a definition for that. And our inability to cure, we are not God, okay? Our inability to cure has been defined as deficiency in service. So this is the scenario now. We should understand that. And I am sure in everybody's practice, you might have come across this kind of impatient patient. They are demanding. They started thinking that whether everything is value for money or not. So these kind of patients we have seen. Now, the legal mechanism is also not different, okay? There is a concept called deep pocket theory. There is a concept called deep pocket theory, which simply says that, let the affordable one pay. Now, this is very easy to understand. Just imagine you have parked your car. Remember, you are not driving. You are parked your OD car or a Benz car on the side of the road, and a negligent bike guy comes and hit your car. Tell me, who will have to pay? Who will have to pay to that guy? Remember, you were not driving. You have been parked on the side. So this is just because, the mob comes over there and he will think that, okay, this guy is having this kind of car. He is a rich guy. Let him pay for the bike guy. So even court started thinking in this way, like, when a patient goes before court, rather than going into the merits of the case, they started thinking, let the affordable one pay. So we have to understand this scenario when we are practicing. And needless to say that we have seen this kind of cartoons in our WhatsApp. Our skill acquisition has steadily declined. Communication skills, imagine the newer generation doctors, how is their communication skills? Patients' demand has increased. Now, this is because of our motivation and our classes and all those things. We have motivated patients for seeking treatment. Awareness have gone up. So, and our need, the doctor's need for money also has increased. So the net effect of that is, in the society, litigations has also increased. Now let's just look at this case. Ankita Khanna versus Dheer Dental Clinic. Okay, here a teenage girl was taken to a doctor for the alignment of the tooth. So the doctor told that there is a mild irregularity and he put braces, and the patient developed pain after 2-3 days, which is very natural. So when the patient went to the same clinic that particular day, that orthodontist or that doctor was not there. So she was taken to a neighboring clinic where the doctor said that, this need not require braces, which require for 1 year, 1.5 year treatment. Your kid is studying, so why don't you go for veneering treatment? And they said the cost will be only 2,400, and within 2 sittings the matter will be solved. So that doctor removed the braces and started reducing the tooth and put plastic caps. But what happened? Patient developed severe pain and they consulted some other institution. They recommended RCT and Crown, and the patient had to go through severe mental trauma, lot of class losses, etc. And the compensation that is put forth is to the tune of 25 crores, which is still in the court. So now we can understand there is a mechanism needed for protection of consumers or patients also. So we cannot totally blame the authorities for drafting laws to control profession. Now imagine this was a picture that was circulated in WhatsApp few years back. One rich guy who is having a Mercedes-Benz car, he purchased it, after 3-4 days there was some problem and he approached the authorities who sailed the car, and they did not handle it properly, and he is destroying it with a golf stick. So basically laws are designed to protect everyone, not an individual set of people alone. Just imagine India without traffic rules. See how people are driving and how things are happening, and see the change recently when the traffic law has been strictly enforced. So there are laws to prevent attacks against hospitals also. We might have heard about this kind of hospital attacks very frequently, especially in Kerala. Now, it is not because of the absence of laws. It is because of the law enforcement machinery. It is not very done fruitfully. So, to conclude this part of my presentation, ours is a profession bound by laws as well as general laws. Its laws means professional laws and general laws. Doctor-patient relationship has changed. We have to keep this in mind, okay? We are no more gods. We have to be truly professional. And these are the important laws that we have to obey in our practice. Now, my next part of the presentation is discussing little bit about what are the effect of these laws upon us. Okay, so I just shift from this introductory part to the effect of laws into our profession. To put it in simple terms, remember, laws fix liability to a professional. That is called statutory liability, because statute means act or law. So statutory liabilities. These are the law liabilities that operate at a personal level. And there is some other liability called vicarious liability, which arise at an institution level. For example, if your assistant does a misbehavior to the patient or does something negligently or do something, you are also liable. That means you are liable like a vicar of a parish or vicar of a temple, who is liable to the sin of that parish members or that temple authorities members. So similarly, that is vicarious liability, and at personal level we have statutory liability. Now, to put it very simple, because Dentist Act is a professional law governing us, we have professional liability due to the Dentist Act. Consumer Protection Act is a civil law, so we have civil liability based on Consumer Protection Act. Now, we are a citizen in India, we have to obey criminal laws like Indian Penal Code, IPC, so that will fix criminal liability to a professional. We have to obey contract laws like Indian Contract Act. I will explain why it is applicable to a dentist. So we have something called contractual liability. And for example, there is something called a tortious liability. Tortious means tort, law of tort. For example, negligence is something considered as a law of tort, a tortious act or a twisted act. So we have something called tortious liability. So these are the kinds of liabilities that we have for being as at a personal level. Now, professional liability, I'm not going to discuss right now in detail. If we needed, we can discuss. Like for example, it fixes, how much advertisement is legal, how much social media advertisement is possible. Like, can corporates run dental clinic? All those things comes under professional liability, and it is clearly defined in Dentist Act. If time permits, we will discuss under this later. Okay. So that is professional liability. Now let me ask you this question. Can a doctor practicing be arrested by a police? Now remember, this comes under criminal liability, okay, under Indian Penal Code. Now a person can be arrested only if there is something called mens rea, which simply means a guilty mind. If somebody commits something with a guilty mind, or if the negligence is so gross that we can call it as a criminal negligence, then only a doctor can be arrested. Now this is held by a case called Jacob Matthew versus State of Punjab. Here what happened was that doctor who was in the casualty attending a old terminally ill person was arrested by the police and put in jail. Now here the Supreme Court came heavily upon the authorities who arrested and said that a doctors cannot be arrested like that if they are doing an essential service, and if they are arrested like that, they will be very hesitant to do treatments. So if the criminal negligence or a guilty mind is proved, then only a doctor can be arrested, and the court has laid out certain guidelines before arresting a doctor. So that is technically or nearly impossible unless there is a kind of misbehavior to patient and other things. Now let me ask this question here, put this question before you. A 12-year-old female pediatric patient was treated for a restorative procedure, and the parents were waiting outside, and the next day the parents claim and said about misbehavior. Now this is not an arbitrary case, okay, these things have been reported in literature, and to my knowledge at least a few cases have happened in Kerala, and I am sure, being an IDM member, you might have discussed this case which has happened recently also. So now how to handle the situation? Now this may be because of, if it is because of a true misbehavior, remember, nobody can help. It will become like a POXO case where the doctor can be arrested and nobody can help, and most of the offenses listed in POXO Act is non-bailable. So there is no means. But if it is a fabricated case, maybe a neighbor's envy or something related to that, or some other issue, forget about that. Now you have to escape, right? So the options are like, you need to have a CCTV coverage in your operatory or the clinic so that you can prove, or my request would be like, for any underage female patients, if males are doing the treatment, you should allow one of their parents at least to be in the operatory while doing the procedure. Now if it is a fabricated, definitely you have ways to get out, and we don't have to worry about it. Now let me discuss the second case also. Here a 52-year-old otherwise healthy patient underwent FBD treatment and he developed cardiac arrest, and the doctor tried to revive, suddenly transferred to the hospital, but unfortunately the patient could not be saved. and they lodge a complaint in the police station. Here again, I am telling you, there are enough literature which says that, women dies during extraction, death in dental clinic scenarios, those are all reported. So this can happen. Now we don't have to be panic about it. Only thing, we need to take adequate precautions to revive and suddenly try to transfer the patient to hospital if it does not, we cannot handle the case. So ensure that you are doing the right thing. Don't get panic. You should ensure that you are taking all steps to transfer. For example, you can stop all the cases and immediately take the patient in your own car to a hospital. And I also request you to have a hospital tie-up also close to your practice, so that you can call and you can do. So ensure that you are doing everything. That's it. Because the reason is that it is not at all a difficult case to defend. Don't bother about it, because if this patient, instead of being in the dental chair, was walking on the road also, this incident would have happened. So you can prove that. But when patient is in the dental chair, there may be some apprehension and some other things. So you should have a proper case history, medical history, and you should try to revive. You should try to transfer to the hospitals. Talk polite to them. That's it. Otherwise, it's not a very difficult case to defend. Now, this slide I am trying to explain how contractual liability arises for a dental practitioner. You might think that I am not doing a contract with patient. There is no valid contract. I am not signed any contract with the patient. Then why should I obey Indian Contract Act? Now look at this. You have put a board, dental specialty clinic, XYZ dental specialty clinic, and fixed it in a public place. Now this is called as a public offer, which is very essential part of a ordinary contract. So you have given the offer to the patient by putting a board in a public place. When the patient enters to your clinic and registers his name there, remember, it is acceptance of the offer. It is called implied acceptance. And when you discuss the treatment plan to the patient and the patient agrees to your treatment, remember, a valid contract is established. It need not be written or put down in letter. Okay, so there is a contract established and your duty to care arises from this particular point. So we as dental practitioners have to obey the Indian Contract Act, and our agreement to treat, even though it is an implied, is in the form of a contract. I hope it's very clear. Now, let me introduce that tortious liability or negligence to you. Now, this arose from a case law. Yeah, this has happened in 1930s, where a female went and purchased a kind of beer called ginger beer. I am not aware of this, okay. Now what happened was, when she came and she was about to drink and opened the beer, she found there are some dead bodies of snail in that beer. So suddenly she developed abdominal upset, mental upset and all those things, and she was admitted in hospitals, and she had lot of other episodes, and it is, they call it as nervous shock. And obviously once she recovered, she went to the shopkeeper and argued with the shopkeeper, and shopkeeper said, no, this is somebody manufactured and I am just selling it. I have no liability. So the matter went before the court, and the court said that anybody who has manufactured or supplying it has got a responsibility to take care of it, and laid the principle called the principle of neighborhood. That means you have to treat like a neighborhood. And this case is called Dono versus Stevenson, or snail in the bottle case. So this was applicable for somebody who is doing some kind of service to a person. It was not applicable to medical or any other profession, but later this principle was imported. This principle was imported into our medical practice. So that is called tortious liability. So I hope it is clear to you. Now let me ask this quiz or a small break session. So be ready, alert. Our CD convener has specifically told me that we should have some quiz session. So my question is this is not the question, okay. I'm going to ask questions. My first question is trial question, okay. So in the trial question, remember, there is no gift, and the second question will be the real question, okay. The trial question is nothing but What is Schedule H drug? I will put the options and you can answer in the chat. What is Schedule H drug? A, B, C, and D. Let's see who scores here. A is homeopathic medicine. B is medicines that can be, can be sold against valid prescription. Medicines that need not require a valid prescription. Exclusive list of abusable drugs. So what is Schedule H drug? Still answers to come. Yes. So your answer is right. The answer is answer B, and I should say the first person to answer that is Parikshit. Okay, so I'll go to the question, the main question. Okay, so next is the question that is going to grab prize for you, and the question is, what is Schedule H1 drug? I hope the first question was very easy. So the question is, what is Schedule H1 drug? List of narcotic analgesics. B, first and second generation antibiotics. C, third and fourth generation antibiotics. None of the above. The question is open to answer. Yes, I got the answer. The answer is Kripa Patil, that is C. Third and fourth generation of antibiotics. So she wins the first prize, and being woman cell and woman only grab the prize, so we are happy. So that is Schedule H1 drug. Okay, now Schedule H1 drug is third and fourth generation antibiotics. That is simply, high-end cephalosporins and kind of antibiotics for which a pharmacy, a drug store should maintain a register of the drugs. Now suppose if you are dispensing this medicine in your clinic, you are also supposed to maintain a register legally if you are dispensing this third and fourth generation antibiotics or Schedule H1 drugs. Okay, so that was the break, and we continue. Now I come to the next part of the presentation, that is elaborating on negligence. Now we have seen the liabilities, and we have elaborated the kind of liabilities at personal level, at the institutional level, and now let us see what is negligence. I am not again going to theory part, just one or two points regarding this. But what is negligence is basically doing what you are not supposed to do and not doing what you are supposed to do. Very simple. It involves two things. The act of commission and act of omission. Okay, doing what you are not supposed to and not doing what you are supposed to do. Don't get confused. I will make it very clear. See, here you can see where the file is, endodontic file. Endodontic file is in the throat. So that means this is an act of commission. You are doing something which we are not supposed to do. So this is act of commission. And here we are not doing something which we are supposed to do. For example, not taking a test dose of injection before giving a local anesthetic when it is mandated, not for all cases. Okay, so that is negligence, act of commission and act of omission in simple terms. Now negligence is not something that is unique or rare. Okay, it says that in United States 1 lakh patients die due to medical negligence. Similar figure in UK and in India also. Now in this picture you can see our late actress Sridevi. Sridevi's mother was undergoing a surgery in United States for some brain lesion. She was unfortunately operated on the opposite side of the brain where the lesion. So this kind of problems can happen in anywhere. At least few of you remember this guy. This is a boy who underwent surgery for genioplasty, and unfortunately due to some anesthesia complication he passed away. Now, we day in and day out, we come across cases like this in literature. So some are really, may come under the ambit of negligence, whereas some are really an accident that is happening, that is does not amount to negligence. For example, right, when I was looking cases in my own department, see how a long hook, that is unprotected hook, is causing injury to the mucosa. That is a negligent act. Now, this is in one of cases long back when I was consulting. One girl, she had an impacted canine on the left side. So naturally, the treatment plan, and that to a dilacerated first premolar. So, my plan was to go for extraction of first premolar on that side, and as his nasolabial angle was not very obtuse, my plan was to go for second premolar extraction on all the other sides except the left side where first premolar is extracted. Now itself, I am sure that you practitioners might have pointed out the mistake that had happened when the extraction pattern is like this. Same thing happened when I went for the next clinic. All the second premolars have been pulled out. Now I could manage this case even without telling the patient, or because I could display and manage it. Thank you. Now, ideally, we are supposed to inform to the patient, explain to them, and handle it. But sometimes, when we try to explain, some issues can happen. Anyway, you have to use your presence of mind and handle such situations when this comes. But remember, extracting a wrong tooth will, in the Indian Penal Code, IPC, according to IPC, section 30320, it is a grievous hurt. Okay, it is a grievous hurt. It is something like, for example, amputating the left leg instead of the right leg. It is as simple as that, because this tooth is considered as a member, an individual member. So it can, so be very careful. So this is exactly what happened, and only solution is to exercise due care. Now let me introduce this ingredients of negligence. There are 4 ingredients of negligence, which is called as 4 Ds. Okay. Now the first one is, you are aware of it, I am sure. First one is called duty to care, which I already explained. When the contract is formed, implied contract is formed, your duty to care arises. That is, if the patient is under your care, you have a duty to care. You cannot neglect the patient. Second one is dereliction of duty, or this is usually the cause of action for any malpractice claim. That means poor standard of care. And the third D is damage. That means the patient suffered some kind of injury. Remember, if there is no physical injury to the patient will always attribute mental injury. That is also valid before a court of law. And the fourth one would be direct cause. That means the injury should be directly related to your treatment. So these are the chain reaction, 4 Ds, that a patient or a patient's lawyer would adduce against a dentist in a court of law. All the 4 things have to be proved in a sequence. So if the dentist lawyer is appearing before court, he will be trying to break one chain out of it. If he is breaking one chain, he will succeed and the dentist will succeed. The patient cannot succeed. So these are the 2 weak links that a dentist lawyer will be trying to disprove. That is, there was the standard of care was adequate. He will try to prove. Or the injury is not related to this treatment. There was a pre-existing condition. That is why this happened. So these are the 2 links usually a dentist lawyer will be trying to break in a court of law. So this is the chain reaction and 4 Ds of negligence. Now, let us see what are the defenses against medical negligence. For example, contributory negligence. That means the patient also contributed to the negligence. That means the patient did not follow up. The patient did not follow the instructions that you give. He did not come up follow up. Like he, after orthodontic treatment or after putting braces or after the first sitting of RCT, he is coming after 3 months. So that is contributory negligence. Act of God. For example, during this COVID period, it is not under our control, or a war situation or a flood situation. You are shutting down the clinic for a few days. So that is act of God. Now, no direct connection. As I said before, there was a pre-existing condition. The damage is not because of my treatment, or no damage really occurred. The patient is, just framing a case against you. So these are the things that we try to, prove in a court if at all there is any case of negligence. And remember, this highlights the importance of, post-procedure instructions and proper documentation. I will come to that a little later. So remember, similarly, there are some duties that the patient also should do. Like, for example, the patient should be truly disclose all the medical conditions to you. And they in case of an emergency, so for example, after extraction, if there is bleeding or some issue, they are supposed to consult you or in a hospital. So that is the duty that the patient is supposed to do. So here again, like history taking, instructions and documentations are being highlighted. Now imagine, suppose if a patient has got some problem or some issue, and where all they can go and address against a dentist. Now why I am saying is that, for us to be alert that where all somebody goes and give complaints. For example, institution head, if in a corporate hospital, if you are working as a dentist, or in a teaching institution, definitely they go to the institution head. But remember, they will not get any financial compensation based on that. The second place where they can go is Dental Council of India, Kerala Dental Council. Here again, the patient will not get any benefit. They will serve a notice to the dentist and ask for an explanation, and that matter will be settled, or maximum you can be put in a fine or things like that. A patient can go to a civil court. Remember, a civil court will take 10 to 15 years to settle a case, and the compensation is also very less. So they will not probably go there. And if there is a criminal offense or things like that, they can even go to a police station and file a lodge a complaint, as I mentioned before. But this is the place where a patient regularly goes if at all there is a problem. This is because consumer courts are patient or consumer friendly, I would say, not patient, consumer friendly. There is fast remedy, there is high money or pecuniary compensation granted at a faster pace. That is why it makes attractive for a patient to go to a consumer court. Now, a little bit about the Consumer Protection Act. Remember, it is not for patients alone to evoke against us. Okay. Now we have purchased something, a TV from a shop, and next day it not working, and if they are not servicing it properly, we also need to evoke the same consumer protection law. So it is a social welfare registration. The first act was in 1986 and the current act was in 2019, the new act. Now, initially when the act was introduced in 1986, okay, remember, medical profession was not defined in the act, but later it was introduced by a case called IMA versus VP Shanda. So from 1995 onwards, medical profession is also included under the Consumer Protection Act. Remember the limitation period of 2 years. That means after the treatment is over, within 2 years, the patient should approach the court. Now, if there is a delay in approaching, sometimes the court can condone a delay, okay, but not beyond a particular limit. So this is the limitation period. Now, in a consumer court, remember, there is no need for a lawyer. E-filing and e-hearing is allowed according to the 2019 Act, and court fees is negligible. That makes the patient more attractive to go to the court. There are three commissions: district commission, state commission, and national commission, where they can approach. Now the steps involved are, like, for example, if you want to approach a court for something, you have to draft a complaint against the firm. Then you have to enclose all proofs like the bills, receipts, etc. Warranty card, if at all it is there. You have to pay the court fees, and you have to give an affidavit stating that you are so and so, bearing Aadhaar number so and so, and you have to submit it to the court. And you will get a reply within 30 days. Now, where should you file the complaint? It can be either district commission, state commission, or national commission. Based on the amount of compensation, you have to approach various commissions. Usually, a patient go to the district commission if the compensation is less than 1 crore. And when the where to find, like, wherever either the complainant or the opposite party resides or carrying out business. For example, if you are practicing within the Tripunithura area, the patient can complain either in the Ernakulam District Commission Forum, or if the patient is coming from Kottayam and taking a treatment in your clinic, remember, the patient can file case in Kottayam Consumer Forum also. application, affidavit, all those things I told. And with the complaint, the law machinery is set in motion. Now what happens? In the district forum, there are one president and 2 members. In each sitting, there should be at least 2 members. And there are 2 courses of action for the complaint for the patient. One is the forum can accept or the forum can reject. If the forum rejects a person's complaint, the forum has to give an opportunity for the patient to listen to their complaint and give an explanation why it is rejected. Now, if it is accepted, then it will serve a notice to the opposite party or to the dentist or the doctor, and the doctor has to give an explanation within 30 days or up to maximum of 45 days. Now, what will next happen to when the complaint or the complaint is received to a dentist? The dentist can either accept it. The accept means we have to pay compensation. If we are rejecting it, we have to give an explanation within 30 days. Now, in the new act, there is a provision like called mediation. That means if the parties are agreeing to the Consumer Protection Act, they can go for mediation. So the decision is usually based on the explanations and the proof brought before the court, expert witness, and usually within 3 months, or if there is any lab test or report is to be obtained, it will take another 5 months to give the decision. Now the advantages I already told, why patients go before a consumer forum. Now let me ask you this question, are doctors in or out of the Consumer Protection Act 2019? Now remember, in the 1986 Act and 2019 Act, doctors' names were not exclusively included. In the draft bill in 2018, medical profession was defined as so and so. But then our IDA, IMA and other bodies launched a strong protest, and medical profession that name was deleted from the Act. That means under the section 2, which defines what all things comes under, medical profession is not there. But that does not mean that doctors are out of the Act, because in 1986 Act also doctors were not there. So doctors are included in the Act based on the judicial decision. And we have recently seen this kind of messages also. So under Act, Consumer Protection Act, even though expressly it is not mentioned, it is included. But don't bother too much about it. I don't want to psych you with this. See, Consumer Court dismisses negligence complaint against dentist. Look at this. Only 15% of medical negligence are genuine. So we don't have to be bothered. We have to take certain steps in our practice, that's all. So with this, I bring my third case before you. A 22-year-old male patient underwent orthodontic treatment for class 2 malocclusion with extractions. Few years later, the patient reports back complaints of relapse and threatens to go to court. Now, this is a case in which I have appeared as a person or an expert witness to defend a dentist. So, how do you handle this case? See, we don't have to worry too much about it, because relapse is not under our control. If the treatment is pakka, if the documentation is pakka, we don't have to bother too much about it. Here, what is needed is, proper documentation of the case. And, regarding relapse, we always tell the patient that relapse can occur. If retainers are not used, relapse will occur. So, what is needed in this case is, proper instructions and documentation of the instructions. So, this is not at all a difficult case to define in a court of law. So, that opens me to the second round of quiz. So the second round of quiz is, there is only one question and answer. Okay, here there is no trial. So I hope you are getting ready. Let me open the chat box. So the question is, this is a problem question. A 13-year-old girl completes her orthodontic treatment after, when the treatment started, it was 13 years, okay? After 2 years, that is at the age of 15, she completes her orthodontic treatment. How long the dentist is bound to store the records after debonding? So I hope the question is very clear. At 15 years, her treatment got over. How long the dentist is bound to store the records after debonding? I'm getting answers. 3 years, 3 years. Let me put the options. Sorry. Got stuck. 1 minute. Yes, we have options: 2 years, 3 years, 4 years, 5 years, 6 years. 10 years, 25 years is not there. Yes, I think I got a correct answer. Let me see who answered first. Yes, I will declare. The correct answer is Jason. It is 6 years. Now I will tell you why it is 6 years. Now, she is a minor at the age of 15 years. So she can approach a consumer court after being 18 years. That means after she becomes 18, that is 3 years, there itself she has leeway. Now after 18 years, consumer court, the 2-year period is there. That means 3 plus 2, 5 years. Now the dentist act has gone one step higher. The dentist has asked to maintain records up to 2 years. So that will technically operate her after she becomes 18 years. That is one reason. Second reason I already told, there can be condonement of delay. Like, suppose if the patient approaches after 2 years, that is at the age of 20 years, and saying that some negligence claim, court can delay it also. So at least a period of 6 years you have to maintain records in this instance, especially when the child is a minor. For pediatric patients as well as orthodontic patients who are minor, we need to store the records up to 18 plus another 3 years. So I proceed further. Slightly stuck, sorry. Yeah. So what I have covered till now is we have discussed about profession and professionalism, laws to be obeyed, liabilities, negligence, avenues of redressal, and how now we see how cases are decided in a court of law in little more depth. Now basically cases are decided based on the evidences adduced, genuineness of the evidences, and fact and circumstances of the case. Sometimes if needed, expert witnesses are asked to be produced before a court. It is, remember, this is the crux of the presentation, okay? Remember, it is not based on the best treatment possible for a same situation. The court will look only how an ordinary clinician have treated this case, whether due care is exercised or not. See, your skill and my skill varies, and between us, if there are 66 persons attending this webinar, have different skills. So that is accounted in a court of law. Okay, so don't bother about it. Court also looks whether you have adequately documented and informed choice was given or not. When informed choice is not given, it amounts to something called a battery or an offense. So that is considered. And finally, in a court of law, definitely there will be a personal element also, for which we have appeals before higher authority. Now let us see, there are certain tests that a court of law applies when a consumer case is brought before a court or a civil case is brought before a law. The first one is called Bolam test. I am sure you are aware of it. This test is simply a very simple test where a reasonable body of professional opinion is there or not. That is, for example, you are having a dry socket after extraction. Now, giving a eugenol, zinc oxide eugenol pack is accepted. It is reported in literature. So if you have done that, so that is the accepted solution. So Bolam test means whether you have accepted according to what is prescribed in the book, or whether a professional opinion, if you take a professional opinion, okay, doctor has done as per what is required. That means your test is passed. But recently there is another test called Bolito test. This Bolito test is a patient friendly test. Okay, the other one is a doctor friendly test. Now, in Bolito test, what happens is that risk and benefit of the standard practice should be weighed. For example, here the court will see that in that particular case, whether giving zinc oxide eugenol pack was adequate or not. So that is how Bolito test applies. Otherwise, it is not like that. Now, the first test is Bolam test is called ordinary prudent clinician test or doctor friendly test, whereas in Bolito test, individualized decision is taken. For example, if you are running a big hospital with all facilities mentioning that specialty endodontic treatment, and suppose if you don't have a working apex locator, that amounts to negligence. Or you are saying that a exclusive specialty practice, and if a specialist care is not given to a particular case which requires specialist care, that amount to negligence. So that is considered in Bolito test. That is a recent addition, and courts have slowly shifting into that. So we need to be very careful. So I told you Bolam test is patient friendly test. In this case, what court has said is the skill of doctor varies from doctor to doctor. There can be more than one treatment option for each case. Opinions may differ, and it is doctor friendly test. Here in this case, Poonam Verma versus Ashwin Patel. Here a homeopathic doctor practiced allopathic medicine and the patient died. Definitely an ordinary clinician should not do that, and the doctor was held liable. When it comes to Bolito test, remember it is a patient friendly test. Here the quality of the care expected from an establishment should be in tune to the reputation of the concerned specialist doctor. So that aspect or individualized decision has been taken in this case. But in this case, the Supreme Court expressed that the courts or lower court should reconsider Bolam test and apply, but it is not very frequently applied also, so don't bother too much. Okay, still the court that follows the test that is applied is mostly Bolam test in court of law. That means a patient friendly test. This institute also, the doctor said that the neurosurgeon was essential for the time of surgery, so court starts recognizing the presence of a specialist. Now I will put forth this $1 million question. Can GPs do orthodontic treatment? Now I am sure there are a lot of GPs also attending. Let me put, I am very neutral regarding this. To be frankly speaking, according to the Dentist Act, a person who is trained, who is capable, or who knows what he is doing can do any form of practice. When medical profession, they say that an MBBS doctor can do even a heart transplantation. That is allowed. So technically speaking it is, but recently we have seen that the after effect of this Bolito principle, Maharashtra Consumer Forum has fined one doctor for doing orthodontic treatment. The doctor tried to say that he had acquired 1 year advanced course in orthodontics and all, but they say that it is not recognized by Dental Council of India. Fine. So this is an after effect of this Bolito, but remember it is not a very rampant decision. Okay, in most of the cases it is the Bolam test that is applied, but the specialty care has been recognized. Now if you look into the code of conduct 2014, there are one clauses written like what are a specialist who is supposed to do, how do a specialist behave. So that was the progression in the legislation, that is the code of conduct has started thinking specialists and their role has been recognized. That is in tune with how the scenarios are changing. Okay, so I leave that topic over there. We can discuss if needed at the end further. Now again continue with the decision in court of law. Expert witnesses are brought before court of law. Expert witnesses can be brought by both the parties, patient as well as the lawyer. Sometimes the court might appoint an independent expert witness. Then both the parties can do cross-examination or examination in chief, which I am not going to technical terms. And textbook and journal references can be adduced. The case that I appeared, the patient's lawyer was bringing photostat copies of journal and articles and asking whether this is correct or not. And if the court is not, or the consumer forum is not pleased with the decision, it can refer to a medical board also for deciding. Now, one who delegates the responsibility to a junior doctor, knowing that he is not capable, also amounts to negligence. And these are some decisions, like here in Chandrika Bai case. This is a very important case. A cotton gauze was negligently left after in the abdomen of a woman who underwent sterilization surgery. Now here, when the case came before court, when the doctor's lawyer stood up in the argument, tried to explain something, the court said, the lawyer counsel, okay, doctor's counsel, he called the doctor's counsel and said, lawyer or counsel, you please sit down. You don't have to tell anything, because this cotton gauze retrieved from the abdomen will speak everything for the patient. That means the doctor's lawyer was estopped, or his mouth was shut and he was asked to sit down. This is called res ipsa locutor. That means the thing speaks for itself. Now, when this is applied in our situation, a broken RCT instrument, when retrieved, or a mandibular fracture per se, will speak for itself that there was a negligence. Now, here again I am telling you, broken RCT instrument can be a normal sequelae. Now, this becomes a negligence only when you have not explained and it is not mentioned in your consent. Mandibular fracture also, if you foresee any problem, chance for mandibular fracture, that should be noted down. Okay. Now, I move on that decision-making process from a court of law to some instances of negligence which I have come across in literature, like, aspiration of irrigation needle. Sometimes when our assistant gives that aspiration to root canal in a second molar, and if the needle is not tight enough, it can fall to the posterior part of the mouth, and remember vagus nerve stimulation, and immediately the person may aspirate it or even swallow. So Grossman, they have reported aspiration, like, for example, here it is written 87% usually aspirates into the, or goes into the alimentary tract, and 13% can enter into the respiratory system. Similar instances are reported in literature. Even in my own college also, once an instance have happened, and the instrument had to be retrieved with endoscopy. I still remember in one clinic which I was consulting long years back, that doctor had tied a thread, a suture tying thread under each file, and she was losing very carefully like that. Otherwise, we know the standard of care in endodontic is to use a rubber dam. So many instances are there. This is another instance that we have to be very careful. Injecting formalin, especially when you are taking biopsies, 58% of the institutions use LA bottle for storing biopsy specimens, and the formalin liquid is a clear liquid. Okay, 40% of the doctors have unskilled assistants. And if I am to confess, there was an instance when I have injected saline instead of local anesthesia, but luckily nothing happened. So this can arise into our practice, and we have to be very careful. And this is a case where Major Gopinath case, where uncontrolled bleeding arose after extraction of a third molar surgery, and the patient had to be admitted in hospital, and there were a lot of ventilation issues and all those things, bleeding time, clotting time, everything was high, and attributed negligence. But finally there was heart problems coexisting, and it was not attributed to negligence. So the doctor could explain, and whether document and all those things, and informed consent, all those things will amount to a secondary issue. Now, a mandibular fracture following third molar. Remember, this is a grievous hurt under IPC section 320 and 322. So, like endangering life situation. Okay, so we have to be very careful regarding that. Proper instructions regarding when we inject and anesthetize children, palsy arising after local anesthesia, or oroandral fistula. Now, these may be normal consequences. These are not fault per se because of our practice. But remember, we need to forewarn them, document them, document it properly to evade from liabilities. Now, are emergencies negligence? Remember, all emergencies are not negligence, but failure to handle an emergency properly can amount to negligence. Okay, failure to take adequate precautions like take proper medical history, those things amount to negligence. Suppose if you don't have these drugs, emergency drugs, these we are bound to have a drug repository in our practice with their expiry dates being proper. Okay, that we are supposed to maintain. We are supposed to be adequately trained for BLS as well as this procedure, administration of drugs. Now, in orthodontic treatment, projecting distal ends, unsafe cutting of distal ends, white spot lesions, extended treatment time, non-vitality following orthodontic treatment, and root resorption, all those things can be instances of negligence which a person can come before court. You might have heard about the TMD issues following extraction correction in a United States case, which is classically referred to as the $1 million case, where the patient succeeded in suing an orthodontist and getting compensation from them. Now, this is one case that I frequently we used to get in our clinic. See how poorly managed orthodontist. Just because being an orthodontist, I get this case. Okay, that is, don't bother too much. See, this is in literature I could get a 64-year-old female patient staying in a single room house in Mumbai has been fixed with these many number of implants, and asked for 1,65,000 rupees. She just staying in a single room rented house in Mumbai. Okay. Now, either the doctor tried to learn how to place implant, or the doctor is mad to put these many implants in patient's mouth like this. Now, don't underestimate the influence of social media. So, this kind of picture has been circulated in social media a few years back. See here what the woman's telling and taking a picture and putting in social media. She alleged dentist pulling her daughter's teeth out when it could have been saved by root canal treatment. So that procedure of pulling out endangered her child's life, and it amounts to grievous hurt. That is her allegation. So remember, social media now things can go viral. So we have to be extremely careful. So with that, let me put my fourth case into air. During endodontic procedure, an endodontic file slips into the throat and the patient aspirates. It goes into the lungs. Patient was transferred to the hospital and was retrieved using an endoscopic procedure. Patient claims negligence. There are enough literature regarding that. We might have heard about it. I am telling, in my institution, I remember a case like this. So how do you handle this case? Now, the standard of care in endodontics is rubber dam. So suppose if it falls and if the item is retrieved from the throat, remember the legal maxim, res ipsa loquitur, the thing speaks for itself. Normally, an endodontic file should not be there in the throat or lungs or intestine. So that speaks for itself. That means it is very difficult to evade from liability in this case. So if at all there is an option, try to settle this case. If there is, proper standard of care like rubber dam or things were not there in place. Yes, I proceed to the last quiz of the day, that is quiz session 3rd. So be prepared, open your chat. Let me open. Okay. Now let me ask you this question. What do you mean by loco parentis? The options are: a parent who brings a minor patient to the clinic, a legally appointed parent who can sign for a minor patient, a responsible person who brings minor in emergency, all of the above. So you have 4 options. Yes, I got the answer. Thank you, doctor. There is Vivo 1919. Let me see if there is anybody before answered. Option number C. It is a responsible person who brings a minor in emergency. Vivo 1919. I do not know the name, so that is the winner. Okay, now I'll explain. Loco parentis is simply like, for example, in a school, a child falls and the central incisor breaks. Now, before they cannot wait for the parents to report to the class and take the child. So immediately the person bringing will be a headmaster or a teacher from the school. So a responsible person who brings a minor in case of an emergency is called as loco parentis, and you can take consent from them and proceed with the treatment. You don't have to wait for their legal guardian or natural parents to come and sign for the consent form. So let me proceed. So to recap, what we have done till now is, importance of laws, doctor-patient relationship, liability, negligence, Consumer Protection Act, and how decisions are made have been covered. So in my next part and the last part of the presentation is how to prevent litigation. That would be the most important aspect. So I call this section or this part as the armors of protection. Now, in your practice, you might have come across a very cute, beautiful, or maybe very elegant, well-speaking, well-dressed person, obeying to all your comments, listening to you, agreeing to all your patients or your commands, but you simply don't know when that person turns out against you. So the only solution is to take universal precaution, or to fix this equipment in your practice. How to identify a potential litigant? Fix this equipment in your clinic entrance, and if the patient walks in, there is a light that blows which says that if it is red means he is a potential litigant. Or the option is to go for this WhatsApp chat with, whether ask in the case history whether you have gone against doctor in the past dental history. Now if these two things are not possible, the only option is to go for armor of protection. That is nothing but proper documentation, which includes informed consent, communication skill, and indemnify your practice. Documentation, I will not elaborate too much and waste your time. Remember this word, fix it in your, write and keep it in your clinic somewhere. Okay, writing saves you. What all constitute documents? Everything and anything that you deal with patient constitutes a document. The basic principles are, remember, the court believes only evidence and nothing but evidence. If not documented, remember, it means it is not done in a court of law. There are so many things which you already know, like, writing of ballpoint pen, everything. Now, only one thing I highlight here is you might be giving telephonic consultations to the patient in this COVID time. Ensure that the next day when you go to the clinic, you make a note of that time, your WhatsApp or whatever conversation, and the timing of that thing in your file, so that let it share responsibility with the patients. And also, if updating of the documents in further visit is a must. The 5 basic elements of effective documentations are: the information gathered should be factual, timeliness, legible, standard abbreviations only should be used, and it should be complete. Complete means, here I will explain it. ഒരു മലയാളം പറയുകയാണെങ്കിൽ ഒരു സിനിമയിലെ തിരക്കഥ വായിക്കുമ്പോൾ ഡയറക്ടർക്ക് എന്ത് മനസ്സിലാകുന്നു ആ രീതിയിൽ വേണം ഡോക്യുമെന്റേഷൻ. എന്നാൽ ഫോർ എക്സാമ്പിൾ, നിങ്ങളൊരു RCT ചെയ്തിട്ടുണ്ടെങ്കിൽ പേഷ്യൻ്റെ കൺസൾട്ട് ചെയ്തപ്പോൾ മുതൽ, ഹിസ്റ്ററി എടുത്തപ്പോൾ മുതൽ, ട്രീറ്റ്മെൻറ്റ് തീർന്ന്, ഒബ്ചുറേഷൻ തീർന്ന്, അതിൻ്റെ ഫൈനൽ റെസ്റ്റോറേഷൻ കൊടുക്കുന്നവരെയുള്ള കാര്യങ്ങൾ കൃത്യമായിട്ട് ഒരു തിരക്കഥ വായിച്ചാൽ മൂന്നാമതൊരാൾക്ക് എങ്ങനെ മനസ്സിലാകുന്നു ആ രീതിയിൽ നിങ്ങളുടെ ഡോക്യുമെന്റേഷൻ കംപ്ലീറ്റ് ആയിരിക്കണം. Now, regarding transfer of records, retain the original documents and release only certified copy except in a court order. When in a court order, you can retain the duplicate with you and give the original ones to the person. Very careful with medical legal records, like when patient comes with fall, history of assault, road traffic accidents, those can amount to medical legal records, and those records need to be stored indefinitely. Now, you should maintain a certificate book in your practice. Whatever certificate you should be issued, a duplicate should be there in your certificate. Maybe after 5 years, a court might issue a summons to your practice saying that you have done RCT for this patient who had undergone RTA and fractured incisor. You should verify it. Okay. And If at all, you can destroy it after a prescribed time, after digitizing the records, or you take photos or making an index and then destroy. Definitely, confidentiality is your record. So in your practice, remember, you should have a record keeping area. Now you can go digital and save space. There are a lot of apps available or softwares available. And you have seen this, court started fining for poor handwriting also. Now let me move on to this informed consent. Remember, the era of paternalism is over. Now you cannot force a patient to any decision. So courts have started recognizing the importance of informed consent also. Your protection of implied consent ends with basic dental examination. Even when you are taking an X-ray also, you are supposed to take, but maybe, IOPA might evade from liability, but at least when you're doing a procedure, you need to take a consent. Regarding consent, you know all those things. I will just fasten out that it should be voluntary, competent, it should be informed, because a mouse click away, all the informations are available to the patient, and it should be prior also. So before consulting you, remember, the patient might have consulted the Google doctor, and the Google doctor would have already given a diagnosis. So this highlights the importance of proper documentation and taking informed consent. Most importantly, remember, you need specific consent for specific procedures, and blanket consent is not valid, which means you have written a pre-consent form, like that so and so, those and like that, and you simply add the patient's name over there and take signature. That is no more valid. Okay, if you are doing a re-RCT or re-orthodontic treatment, fresh consent is mandatory. And for anesthesia as well as surgery, in case of an orthognathic surgery, or you are doing pediatric patients, you are undergoing a procedure under GA also, and everything requires separate consent, and patient and doctor should sign the consent form. Now here I have taken root canal treatment as an example. You have to explain how it is done, how many sittings are needed, plus or minus number of sittings, what are the anticipated complications that can arise, and how it will be handled if it occurs, like for example breakage. If it occurs, how you will handle. The need for the crown. See, many times we fail to explain to the patient, or we will intentionally or unintentionally don't tell that you need a crown after treatment, for various reasons. So that amounts to negligence. Cost of the treatment has to be explained, dated signature. Most litigations if you look into are around extractions or RCT or implant related. Now here, this is a standard informed consent form available in the net. You can take that net and you can modify it to your situation. Okay, here what all things, let us see what all things are explained. In the initial part, they have explained about the chance of failure, no guarantee given, the possibility of hidden problems have been explained, future issues including suppose if it could not be saved, extractions are needed, has been explained, risks that can occur following RCT has been explained, other treatment options, if you don't do any treatment, what will happen has been explained. The possibility or the need for crown has been explained, and finally it is stated that I am satisfied, or the patient so and so is satisfied with the explanations given and the dated signature part. So these are the essential ingredients for any informed consent. Even if you are designing one for your practice, all these things are to be considered. You can get a standard form from net and you can modify. Now in addition, for example, in a root canal treatment, LA is included. So LA complication, need for X-rays, time per sittings, all those things can be included, can be explained in the consent form. And finally, don't forget to customize your consent form by adding a column in between. Like for example, before the satisfaction and explanation part, you add a column where you mention the specific information pertaining to this case. So that will make it an individualized consent for your form, and it will be time saving also for you. Now the ultimate test of this informed consent in a court of law comes when they say that when the patient says that if I had known this before, I wouldn't have opted for RCT. Then the court will turn out to the doctor's lawyer and ask whether the consent is flawed or not. Now for implantology, again, similar consent forms are available in the net, like explaining about the need for surgery and placement of the substructure, alternate treatment, what are like crown or bridge or denture, risk and complications, sinus penetration, or all those things have to be explained, or loosening of the implant has to be explained, average time required for osseointegration, possibility like, smoking is a severe problem in implantology. So smoking and alcohol and uncontrolled sugar, hyperglycemia, all these things, anesthesia and its complications, health, they have the duty to reveal their proper history, loosening of the implant, need for radiographs or scans, CBCT scans, consent for photographs. Obviously, you will be recording an implant case with photographs, and you have to customize by adding what is specific for that patient. And finally, I understand so and so and the signature. So that is how you make a consent form for implantology. Similarly for extractions, it will be like injury to the nerves, bleeding, possibility of dry socket, sinus involvement, infection, everything is info. Now that amounts to what is called as patient information sheet. Now you can circulate this even before when a patient is sitting in your chair also, and the last part deals with the informed consent, which you are going to spend time and explaining to the patient. When patient is undergoing orthodontic treatment, similarly you can design a form like, it is a cosmetic treatment, need for extractions, breakages occurs means treatment will be delayed, cost of the treatment, alternative treatments, white spot lesions, retainers, etc. can be explained. Now personally what I tell that, I never give guarantee to any patient that, your problem can be corrected. What I tell the patient is that you have a problem. I am reducing your bigger problem to a smaller problem, that's all. Like, you have a severe proclination, I am reducing from that situation to a smaller problem. And there will be changes throughout life. I cannot prevent that, for which I give you retainer, and you have to maintain that retainer as long as you want this result to be maintained. Now, this is a consent I use in my practice. For example, here I give a detailed information sheet, and I have customized it by saying the box. For example, here the patient had a history of asthma and under medication, inhaler treatment. So I mentioned that, possibility of root resorption and root shortening has been explained. Also need for periodic X-ray has been warned, which makes the informed form sheet customized to the patient. Now I can understand there are certain roadblocks to consent process. I can really understand that because I was a practitioner long back. Now, even though I don't run a practice, no, it is a time consuming process. Explaining, clearing doubts, alternate plans, expected complications. If I sit and do from morning to evening, I will see only not more than 5 or 10 patients. You may be having 30-40 patients. How to do this? You will be asking me like, what will the patient think, whether the patient underestimate me, like thinking that, I am not competent. That is why this doctor is asking all these things. Or, are my neighboring practitioners doing, will I lose my clients if I go ahead with this kind of consent and all those things. Now, see, it is difficult to initiate and implement all of a sudden. I can understand. But if somebody has not really started right from day one, you have to start. Till yesterday, because patient will think, till yesterday there was no such formality, then why suddenly, when you introduce suddenly? But I have a way out for this. So you have to overcome this roadblock, because the specialty associations or IDA can induce patient awareness. Now, it should be made mandatory. I would say, if at all any teachers listening me, it should be made mandatory from third BDS onward. For every procedure, they should start taking informed consent. Then gradually the patient also will be, getting aware, this is a mandatory thing that I have to disclose to patients, to doctors. Then you can initiate this process in the reception desk. The patient, if the patient has come for RCT, in the details, the patient information sheet you can circulate. You need to customize only when the treatment is started. That means you can save time. Also, if you have an assistant doctor who is there, who has time, you can delegate it. Or even to a trained assistant also, you can delegate the process. Only the crux or the main matter you need to note down. Suppose if the IDA insists on hanging this mandatorily in every practitioner's clinic, then why do you want to bother? No consent, no treatment. So now another important, see, COVID-19 time when we opened our practice, how many sheets we circulated to the patient? Did they tell anything that I will not sign and give and all those things? No. So that was the ideal time to initiate the consent process. At least we should start with a blanket consent form, and gradually as you refine, you come to a thorough, a customized consent form. Let there be something at least, because in a court, at least if something is there, your lawyer or our lawyer can defend it in a court of law, rather than having nothing. And remember, informed consent is not everything. If our treatment is flawed or documentation is not there, that will not help us, but consent is very much important. Now, look at this case. This case came to me, and I was putting implants for bimaxillary protrusion. See, on the lower right quadrant, when I put implant, the implant fractured, and the part was inside the bone. I could have gone for trepanation as the procedure, but for which I need consent. So I have to talk to the patient. It is a delicate situation because I did not explain that implant can fracture. So remember, obtaining consent prior is informed consent, but obtaining consent after is a mere excuse. Now, being in an institution, I had no problem and I escaped, and patient was very understanding, and that is left in place, and then 2 years I am following up and there is no issues. So I could evade. So you might remember this person, at least seniors would remember him. He was a very good batsman. His name was Raman Lamba. He was batting very close to the crease, very close to the batsman, and a ball strongly hit on his head, and within 1 or 2 days he passed away. Now my question is very simple. Can his parents or his wife sue the batsman for negligence? Now definitely your answer will be no. I know, I'm not asking you to unmute and say, because he being there, standing there, has given consent. It is not a written consent, it is called an informed consent. That means the legal maxim is voluntary non fit injuria. That means if you have consented, you cannot complain. So this is the principle behind informed consent. Next is the most important aspect in practice to prevent litigation is communication skills. Here most litigations arise because of poor communication. 95% of litigations arise by an adverse comment made by a fellow dentist. So to continue, most of the patients will complain that doctor did not hear me, he did not listen to my complaints, he did not explain. If I had known this before, I wouldn't have undergone this. The cost was not explained. I did not know that the treatment takes this long. So patient get a feeling that something is being hidden from them. So that is the importance of proper communication skills. So I leave that out there because we all know you are practitioners. Let me come to Arun sir is okay. Thank you, sir. The last case is 35-year-old female patient developed pain following RCT and went to another clinic where they told this teeth cannot be saved with RCT and indicated for extraction. Remember, the other dentist told that it cannot be saved with RCT and indicated for extraction. So underwent extraction. 2 days later, the patient's husband reports to the first doctor and asks for a refund. This is based on a real situation, and similar cases are being reported also. Now, how to handle this case? Now here, what I wanted to highlight is 95% of the cases arise because of a adverse comment passed by a fellow dentist. Here, unfortunately, the RCT treated doctor was not there when the patient reported to the same clinic immediately 2 days or 3 days after the RCT. So patient, the clinic doctor or assistant or somebody might have given some drug and the patient had to seek some other care. So that is actually a negligence or lack of care, I would say. But this is again like either you can give the refund and get away with the liability, or you can even fight out if you think you are pakka. So this is a case that you can win or lose. Now I move on to the last part, that is indemnity insurance. Indemnity insurance is where a third party is taking your liability. For example, for injury, death due to negligence, or claims made against such errors, or even the advocate's fees or cost of litigations are being taken care of by a third party, but it will not cover any criminal cases covered, or situations like acts done under the influence of alcohol, or loss of goodwill, penalties due to non-compliance of statute, AIDS related matters. All those things are not being covered under indemnity insurance. Now, some factors that you should think before you are selecting a policy, like your nature of practice, your nature of the firm, risk involved, like if you routinely do general anesthesia cases and all, type of patient seeking care, like based on that your coverage should be quantified, your coverage should be wide. Your place of establishment, it says rural, semi-urban, urban, if you're practicing in metro, based on that your coverage should be adequate enough. Now, regarding duration of the coverage, there are two kinds of policies. One is occurrence coverage policy. That means any claim during the policy period will be covered. Now, sometimes the incident might have occurred before, but the claim is arising during that period. That means it will be covered. But whereas claim made coverage policy means only those claims that arise and claimed during that period only will be covered. So we have to be very careful when selecting. Suppose if we are stopping practice, or like we want extended coverage, means we need to take a tail coverage for extended period. So based on that we need to plan our coverage. Now, based on the amount of cover, there can be two types. Like any one claim policy means, if for example, if there is a cover limit is 1 lakh and there are two claims in one particular year of 75,000 rupees, that means the company will pay both, because the individual claim has not come up to 1 lakh. So two claims will be claimed. That is for any one claim policy, any claim not amounting to the maximum, that is 1 lakh. Now, aggregate claim policy means, like here there is a limit of 1 lakh. So whatever number of claim arises, the company will pay only to the maximum. That means in this instance, if two claim arises, the amount will be 1,50,000 and the company will pay only 1 lakh, and 50,000 will be taken from the pocket. Now, as with any insurance policy advertisements, insurance is a matter of dash 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 dash. Please read the policy documents carefully. Now, why should we bother too much when we have IDA or specialty associations to take and to discuss matter and do the best policy for us? Just leave it to them. Some fact check regarding indemnity insurance, like it was introduced by IDA in 2012 in the 65th IDA conference in Mumbai. And to my knowledge, when I compare with many other states, Kerala IDA is doing this excellently well under the name IDA Hope. This article says that 52% of practitioners don't know about the professional indemnity insurance, and only 8% of the practicing dentists have an insurance cover. There are various third-party agencies providing insurance, and I believe that IDA will have contract among, they keep on changing contract for the benefit of patient, and they do it beautifully for the practitioners. Now, regarding how much cover, this manuscript states that a minimum cover suggested is 10 lakh, and if you are practicing in a metro, at least you should have a 15 lakh cover. And if you are having a high-end practice, like you are an oral surgeon, implantologist, and or doing more than 10 elective procedure per day, you can even think of higher coverage. So IDA Hope, you might have seen the last year's 2021 years report, summary report. You can see how many cases are pending before court. So this simply highlights the importance of getting indemnified in your practice. So to the fag end of my presentation, let me tell you, prevention is better than cure. One satisfied customer may or may not bring a new one for you, but remember, one unsatisfied customer will turn down at least 10 other customers. So suppose if unfortunately a litigation happens, let us now see what do's and don'ts we should do. First thing is, of course, don't be panic. event can happen in our practice. We are human beings, we can err, okay? So error can occur. Sit down, recollect all the events, write down the events in a chronological order, seek the help of your assistant, make them sit down and brainstorm them and tell regarding that patient. Retrieve all the records including recall history, mobile messages, cast, lab reports. In labs, like for example, I'm not naming the labs, well reputed labs where we give our lab work, they store their records, because when I have gone to that Muatura lab for a lab visit, I could see that they could take a duplicate cast and they store it. So you can request for that cast in case if needed. See for the CCTV footage. Try to negotiate. If you think there is a the case you can discuss with your lawyer, and if you think there is a poor case, then you can try to negotiate. But you don't have to go out of the way. Okay, I am against that. Going out of the way. For example, if there is situation where you think that it is little difficult, then you can negotiate, or than going into case and all those things. Suppose you can enter something like waive of remaining bill or undertake further treatment with concession and get into all those things. But still, remember, patient will have an edge to go for case at any time. With the third party, with a lawyer, you can enter into an agreement. Now, if at all you are giving some money back, in that instance case that I mentioned, that RCT, that actually that doctor gave that money, some money back and settled that case. And in that instance, remember, you should enter into an agreement. You don't just, when the patient walks in, you don't give. Simply you tell that I will give the money back, then they will be happy. You tell that I will talk to the endodontist and tell, then they will come after 2 days. That calm down that situation, handle it carefully, and make an agreement in a 50 rupees stamp paper or 100 rupees stamp paper. Write it. They will write and give when they get the money. So try to get into an agreement and then give the money back. Of course, approach lawyer and present your case and proceed what he say, and definitely we have idea having panel of lawyers. So don't argue with the patient. Argument cannot win the case. Control your paramedics. They also should not argue with the patients. Don't issue any records without adequate backup. Okay, issue note and receipt from the patient has to be taken if you are giving anything back to the patient. So make sure you maintain proper records. Now, sometimes the patient may go and file or put the case in police station also. Don't be panic. Police can call you or summon you or call you to the police station. It is very rare, but if it was called, just attend with a trusted colleague or a lawyer or a respectable person. Be very polite and present your case. Don't give any critical evidence in police station, because case cannot be settled in police station. And if the patient parties try, you can negotiate the case. Regarding selection of a lawyer, it is very crucial. My suggestion, there is a personal bias. Okay, you may be having a very close lawyer friend. I would suggest somebody who is really experienced in dealing with consumer cases, can understand your case and proceed accordingly. And definitely you have indemnity schemes and professional body of lawyers who are expert in this will be there will be a panel of lawyers. Select them. And finally, remember, the bench can matters in a case. A good lawyer knows the law and a great lawyer knows the judge. So if I am asked who is a model practitioner according to me, I would say a model practitioner is a person who is qualified and licensed to do practice of dentistry, who have adequate skill and knowledge, and who keeps on updating the knowledge by attending CDs. Select the patients judiciously for treatment. Now, this is a very important point, because everybody who walks into your clinic is not your patient. Remember, that may be a patient who is rejected by your enemy or a neighborhood or some other practitioner. You are grabbing and inviting trouble to you. So discuss, think judiciously and select patients. Okay, take proper case history and documents. There will be warning signs from when you talk to the patients, how they are, how demanding they are, how they are asking about things and like that. So you are experienced practitioner, and I'm sure that you know about it. Make patients participate in the informed decision making process. Deliver accepted standard of care to every patient. And a model practitioner will communicate effectively to each category of patient. That means you will be having a 3-year-old child, 12-year-old adult, 13-year-old adolescent, 21-year-old young adult, 30-year-old adult patient, 60-year-old senior citizen, 85-year-old super senior citizens. So you have to talk and communicate to them effectively. And finally, a model practitioner will be definitely an indemnified practitioner. So my take-home messages are: be very professional, okay? Because we are now in the professional and trade era. So follow the code of conduct. Practice law according to, we have to practice according to the law of the land. Remember, law is not to harass us. It is an instrument which offers protection to all. We keep these armors of protection in mind: good communication skill, documentation, informed consent, and indemnification of the practice. So exercise due care, enhance skill, and be empathetic to your patients. So with that, I rest my case. That's all, Your Honor, for discussion. Thank you. Thank you very much for your kind hearing. The forum is open for discussion, I guess. I will unshare now.
Thank you so much, sir. That was a wonderful session from you. We could have, many valuable inputs on this topic. We could get few. And may I now invite Dr. Jason, an apt person, the Hope representative of IDA Tripunithra, to handle the question and answer session. The audience are requested to post their questions on the chat box.
Thank you.
Dr. Jason.
Thank you, Dr. Abhinaya. Actually, there are a lot of chats coming up, but it's all about thanking sir. Excellent presentation, very precise, very concise. Nobody's asking any doubt. He was so clear and absolutely clear, and he has covered maximum area during this time. Till now, no question has come because he was very clear on everything what he has told. Can a GP do RCT? It's a question from Dr. Joseph.
Yeah, see, as per Dentist Act, even for ortho or anything, I'm still again emphasizing, as per Dentist Act, anybody can do anything as far as done, but that should amount to a basic procedure, provided there is no complication. The problem arises only if there is a problem. So technically, if, as per law, a person is capable of doing it, there is no harm, but if you think the case requires expert skill, it would be always better to defer and give it to a specialist. So, I mean, it is little difficult to answer that way, but legally speaking, a person can do. But recently, the courts have started recognizing the specialist care. So,
actually, as long as there is no problem, patient is happy, there is no pain, there is no problem.
No issues.
Any speciality.
Yes.
So according to our proficiency, we have to decide whether you should go for it or not.
Yes, sure.
And Dr. Arun is asking, sir, what's your take on dentists practicing hair transplant and facial aesthetic procedures?
Yeah, that is again a good question. Very good question. Thank you for asking that question. But again, to answer that, whether they have certified and answered or not, I do not know whether the skin specialty people will come up against one day for that or not. If, being a maxillofacial surgeon, they are probably trained little more regarding all those things. But when a general dentist does it, whether they're adequately trained or not, we don't know. We are yet to get complications and cases related to that. So we are venturing into an area out of the scope, our technical scope. So there is risk involved, but make sure you have proper certification documentation, all those things, if at all you are going, and try to get proper courses and things related to that. And again, the same thing holds good as long as there is no issues, no problem, nobody brings before court, there is no issues. But when it comes before court, we are yet to see how the legal course takes its turn. So
Okay. And even in that, informed consent is very important. And when it's sent for an expert opinion, if it's coming to somebody practicing dentistry along with the hair transplant and facial aesthetics, they may be siding towards the dentist. But if it goes to some dermatologist or specialist as
Exactly.
a panel, then they will be blaming us.
Yes, yes.
What about dentists selling medicine post treatment in the clinic, whether it's legal or not?
That is a very good question. That is clearly mentioned in our Dentist Act that for the if it is pertaining to our practice regarding analgesic, antibiotic, mouthwashes, toothbrushes, all those things we can store and dispense. So there's no issue at all, provided we follow the stock. You know, we have a stock. Like if it is H1 drug, we should maintain a register. If at all, like, you know, psychotropic drugs may be little difficult for us to manage. Whatever is there, even if some kind of drugs we will be able to deliver, but what all things registered to be maintained has to be maintained. But as long as the drugs that are dispensed pertaining to our practice, we can do, but we cannot sell medicine for a prescription of another clinic or another practitioner's prescription. That is to be taken care. Thank you.
Okay, thank you, sir. And how long we have to keep our patient's record?
Yeah, that is according to the Dentist Act, it is 3 years to be maintained. Ordinary case, okay, not medical legal case. And according to Consumer Protection Act, the patient can sue up to 2 years. But if the patient is a minor, remember, if you have done the treatment at the age of 12 years, patient can sue at the age of 18 years also. So 18 plus another 3 years is the term. So if it is an adult patient, you have to maintain for 3 years. If it is a adolescent patient, after achieving the age of majority plus 3 years will be the time. And if in a medical legal cases, there are differing opinions. Some say that 10 years, some say 25 years, some say that it has to be indefinitely stored. So preferably in a medical legal case like road traffic accident and all those things, better to store it indefinitely, or at least when the medical motor accident claim is settled.
Okay. In case of fillings, we use the word permanent filling, and if it comes out, or even in regard to bridges, a permanent bridge, and if it comes out, whether the patient can complain.
Yeah, that is just a matter of use of the terminology only. Like we for fixed appliances also permanent braces we say sometimes. So that is not. I mean, that is something which based on patient's understanding. Now legally, when it comes, it is not a matter that we can defend, because from the literature we know that amalgam restoration can fail, or crown and bridge can come off. So that is not at all an issue. Only thing, try to clarify as much as possible to the patient that permanent filling doesn't mean that it is permanent. It is technically, literature wise, it is like there are instances that I have done restoration and it has stayed for 30 years, or I have a restoration in my mouth which has been done when I was in the 10th standard. So that doesn't mean that other restoration. So that is a matter that we need to sit and explain to the patient, and based on that term alone, if the patient goes to the court, it is a simple case to defend. There is no problem for that. It's just
whether dentists can take classes and like skill enhancement programs, and whether it's legal or not.
Yeah, obviously skill enhancement is something that is provided in the code of conduct, that all dentists should attend skill enhancement, and it is provided as a duty that you should teach. Now the question arises, when to what extent your teaching varies. Now if your teaching goes to the extent of hands-on training and like that, especially when it is not permitted from the Kerala Dental Council, which is supposed to monitor, when that goes to that extent, only the problem comes. Otherwise, you can take, for example, I am taking a class here, tomorrow somebody else can take a class for general benefits of I tell you that see, there is the Indian Penal Code decides a case based on mens rea. I already mentioned, that means guilty mind. The mind is the question. So when that thing is being applied here, like with what motive you have taken the class? Is it really for the doctors to enhance their knowledge and to practice in standard format, or whether it is to make money for your benefit or not. So that question is very clear. So that will be assessed by the dental council members or before a court of law. That's it. So technically you should do classes and take, but when it crosses beyond a limit to the extent that you are bypassing certain procedures like, you know, orthodontic treatment or endodontic treatment or implantology and whatever, that structured course by a university, when it is bypassed, it amount to some kind of malpractice.
Are there any ethical ways of advertising, like in social media marketing?
Yes.
Are they legal?
That is again a very good question. Thank you very much for asking this question. Now, frankly speaking, I am actually for advertisement, okay, to be frank, because see, you spend money, you practice, and you should know. I remember one doctor whom I have consulting long back. He is a person who, very gentle person, very good person. He retired from German dental service. He told me that when they are doing 30% of their returns, their practice income, they spend it for advertisement. That means people should know what you are capable of, right? So here, unfortunately or fortunately, I should say, our dental, law is slightly restrictive in that. I should say that I'm very, you know, if I'm mistaken, I'm so sorry. I will say that even the Indian Medical Act is little more forgiving, or now it is replaced by the dental, what you call the NMC, National Medical Commission Act, and all those. So that is more for example, I can see Vasan Eye Care advertisement on the bus, on the side of the bus, or one doctor holding 2 kids in the hand and advertising for infertility clinic, whereas dentist is not. So anyway, we have to obey the law. Like, you know, we have to advertise ethically, for which the Kerala Dental Council or the Dentist Act has prescribe certain methods, like when you are starting the practice, when there is a change in your practice, when something newly added to your practice, when there is, you know, some new equipment that is being purchased or anything. So such instances you can advertise. Now, regarding social media, now everything is in social media. Regarding social media, what we have to be bothered of is, like, you know, you cannot advertise staying in this ethical and this thing, okay. You cannot advertise saying that, you know, you are doing this treatment for this cost. All those things is not possible, but you can present your case, like in Instagram or Facebook, like, you know, you are successfully treated RCT case, your smile aesthetic, cosmetic, how you have changed the smile, that you can advertise. I mean, you can purposefully, you are not advertising, you can present it as a case that you have treated in your practice. Showing or showcasing your skill is permitted, but you cannot say that for this much amount I have done this. If you come to my clinic, I will do this, or these things are done in my practice, and you visit me for these things, and put your phone number and all those things. That is not permitted. But you can showcase your cases in Instagram or Facebook or things, and that is a real ethical way to show your skill and let the public decide where to go and seek it.
Yeah, one last question we'll take. Can a dentist do a camp individually or advertise in publication?
No, that is also not very ethical, because that is considered to be for the benefit of his practice. That will be considered as, you know, exploiting the people who are not aware for the benefit of his. That means he is seeking, here is called soliciting for his own. That is clearly mentioned in the act also, like, you know, without any authorities like Indian Dental Association or Kerala Dental Council, or with the proper authorities permission, and with the motive of, you know, proper encouraging their awareness and all those things. Without that, when it is being conducted, that can amount to malpractice.
Yeah, idea is doing a lot of CDH activity as well as camps. They are doing things along with the Kudumbasri as well as Rotary Club and different clubs and old age homes. So anybody who is interested in camps, or anybody who in association with some residents association want to do camps, they can very well approach our CDH chairman or the secretary or the president, and we'll be able to organize it in an ethical way. Thank you very much, sir. It's like a long 2 hours, but you have kept everybody alive, and thank you very much for the informative and excellent session. Thank you so much.
Thank you. Thank you very much. Thank you.
Thank you, Dr. Jason, for handling the question and answer session. Dr. Sivi has raised hand. Dr. Sivi, if you want to ask something, you may go ahead.
നമസ്കാരം എൽബി സർ, സിവിയാണ്.
Thank you, sir.
ഒറ്റ വാക്കിൽ നന്ദി പറയട്ടെ. ഒരൊറ്റ സംശയം കൂടെ. കൺസെന്റ് ഫോമിൽ ഒപ്പിടാൻ പറഞ്ഞാൽ പേഷ്യന്റ് മര്യാദക്ക് ഒപ്പിടില്ല. അതിന് എന്തെങ്കിലും ഒരു പരിഹാരം ഉണ്ടോ?
അല്ല, അതാണ് നമ്മളെ നോ കൺസെന്റ് നോ ട്രീറ്റ്മെന്റ് എന്ന ബോർഡ് ഹാങ് ചെയ്യേണ്ടി വരും. ആക്ച്വലി കൺസെന്റ് ഫോമിൽ ഒപ്പിട്ടേ പറ്റൂ. കൺസെന്റ് ഫോമിൽ ഒപ്പിട്ടില്ലെങ്കിൽ നമുക്ക് ട്രീറ്റ്മെന്റ് ഈവൻ ഡിനൈ ചെയ്യാം. നമുക്ക് ട്രീറ്റ്മെന്റിലേക്ക് മുമ്പോട്ട് പോകാൻ പറ്റില്ല എന്ന് വേണമെങ്കിൽ പറയാമെന്നുള്ളതാണ്. അത് കൺസെന്റ് ഫോം ഒപ്പിടേണ്ടത് ഒരു മാൻഡേറ്ററി ആണ്. അത് ഇപ്പോൾ ഒരു ജനറൽ അനസ്തീഷ്യക്കോ അല്ലെങ്കിൽ ഒരു സർജിക്കൽ പ്രൊസീജിയറിന് പോകുമ്പോൾ പേഷ്യൻ്റ് അത് പറയുന്നില്ലല്ലോ. അപ്പോൾ എന്നതുപോലെ തന്നെയാണ് ഒരു പ്രൊസീജിയർ. ഒരു പ്രൊസീജിയറിന് അതിൻ്റെതായ റിസ്ക്കും ബെനിഫിറ്റും ഉണ്ട്. നമ്മളത് എക്സ്പ്ലെയിൻ ചെയ്യാണ്. പേഷ്യൻ്റ് അത് ഇട്ടേ പറ്റൂ. അങ്ങനെ ഒപ്പിടാത്തവർക്ക് ലീഗലി നമുക്ക് ട്രീറ്റ്മെൻറ്റിൽ നിന്ന് അബ്സ്റ്റെയിൻ ചെയ്യുന്നതിൽ തെറ്റില്ല. പിന്നെ നമുക്കറിയാം, നമുക്ക് പേഷ്യൻ്റിനെ അറിയാവുന്ന സ്ഥിതിക്ക് നമ്മുടെ പ്രാക്ടീസ് നഷ്ടപ്പെടാതിരിക്കാൻ ഉള്ള ഒരു കമ്മ്യൂണിക്കേഷൻ സ്കിൽ വഴി ഹാൻഡിൽ ചെയ്യുക എന്നുള്ളതാണ് ടെക്നിക്കലി ഡീൽ ചെയ്യാൻ.
സാർ, പേഷ്യന്റ് ഒപ്പിടുന്നുണ്ട്, പക്ഷേ ജസ്റ്റ് വരയ്ക്കുന്നേ ഉള്ളൂ. ഫുൾ സൈൻ ഇടാൻ ഒരു മടി.
അല്ല, അത് ആക്ച്വലി പേഷ്യന്റ് അത് ലേറ്റർ നമ്മൾ പേഷ്യന്റ് ആണോ ഇട്ടേ എന്നുള്ളത് ഒരു ക്വസ്റ്റ്യൻ, ഒരു എന്താ പറയുക, ഒരു ലീഗൽ ഇഷ്യൂയിലേക്ക് വന്നു കഴിയുമ്പോൾ ചുമ്മാ വരച്ചുകൊണ്ട് കാര്യമില്ല. അത് അതിന്റെ ഓണർഷിപ്പ് പേഷ്യന്റ് എടുത്തേ പറ്റുള്ളൂ. അപ്പൊ അത് അവർ വരച്ചാൽ അത് അവരുടെ തെറ്റാണ്. അത് അവരുടെ ഒപ്പ് മാറ്റിയിട്ടത് അത് അവർ കള്ള ഒപ്പിട്ടു എന്നുള്ള രീതിയിൽ നമുക്കത് ആർഗ്യൂ ചെയ്യാം പിന്നീട്. ദർ ഇസ് നോ ഇഷ്യൂ.
താങ്ക് യു സാർ. താങ്ക് യു വെരി മച്ച്.
Thank you, sir. For
May I now request Dr. Jason to hand over token of gratitude to our speaker, Dr. L.B. Peter.
Sir, on behalf of IDA Tripunithra and also on behalf of all the delegates who have attended, thank you very much for the wonderful presentation, and we offer this certificate of appreciation to Dr. LB. Thank you very much for your time, and thank you for explaining everything in detail. Thank you, sir. Please accept our certificate of appreciation.
Thank you.
Thank you, sir. Now moving on to the next, we have a brochure release for the next CD program by IDA Tripunithra. May I now request Vice President IDA Tripunithra, Dr. Vijit, to do the honors. Dr. Vijit.
Yes, first let me thank Dr. LB sir for elaborating on such an intricate topic. And he kept us involved all throughout these 2 hours. It was really great to hear from you, sir. Now, I'm honored to announce the first ever stand-up CDE program. Yes, stand-up CDE program, Kaliyil Alpadanda Karyangal, by our own dynamic speaker, Dr. Sivi Pulayat. Request all of you to participate in this program, and along with being entertained and informed, be a part of the history, because it's the first time that such a concept is being carried out. Great concept by Dr. Sivi Pulayat. So requesting all to participate in the program and make it a success. It's on March 13th, Sunday, 7 p.m. Thank you.
Thank you, Dr. Vijit. So with this, we conclude today's program. So may I now request Dr. Vijit, Vice President IDA Tripunithra, to say a vote of thanks.
Yes. Okay. Yes, thank you, LB sir, for elaborating on such an intricate topic in such a simple manner with all apt examples. We know that patients are getting more and more informed, and they are becoming more and more expressive with social media in their hands. So this topic is becoming more and more important, and I think we all should remain abreast with the latest developments in this regard. So once again, thanking you for enlightening on this topic. And thank you, CD Chairman, for selecting and inviting such a great speaker. Thank you.
Thank you, Dr. Vijit. So that was once again, thank you, Dr. LB sir. That was a very wonderful and informative session, which is the need of the hour. So with this, we are concluding today's CDE program. Thank you. Good night.
Good night.